I'm Melanie Reese. I'm the Street Resolution Coordinator. I know most of you, and I'm very excited to welcome Art to our department. One of my favorite things about this job is that I get to introduce Art occasionally. So Art comes to us by way, this time, of Vermont. He spent part of his time in Hawaii. He is a national IDEA expert and is on the other end of my red phone. Whenever I have a crisis or a concern, it's usually Art on the other side, and he always answers, which is wonderful. Today he's going to talk to us about two different topic areas. This morning we're going to talk about Ninth Circuit Court and hot topics in special education law. The afternoon session from 1 to 4 is going to address issues of discipline, and it's a lot of areas of discipline related to special education. So please ask questions as we go, and don't be shy. Art will try to remember to restate them for the camera. You are being videotaped. If you miss something, don't worry, you can come back and listen to it later. So with that, enjoy. Thank you, Art.
Thanks, Melanie. Well, good morning.
Good morning.
So, last week of July, a day of special ed law. Doesn't get much better, people, does it? And I know I'm not in Vermont. When I landed yesterday, it was hot and sunny, which was, we're not accustomed to that back where I'm from in Vermont. So, just a couple things. I know several of you. I have a named disability, so if I just say, hey, you, don't be offended. I also have had the privilege of working in Idaho. We were trying to figure out last night, probably going on 30 years. And I am not an attorney licensed to practice law in Idaho, so here's my little disclosure. Some of you have heard this before. Ethically, I cannot provide you legal advice. I'm not an attorney licensed to practice here, nor is it the intent today of giving you legal advice. I want today to be practical, and I want it to be useful. I do love getting questions and comments. We will assume any question or comment is based on a hypothetical student in a hypothetical school in a hypothetical state that starts with an I. Therefore, in a real situation, please consult with the necessary authorities back home. We're in special ed, right? So I'm asking for an accommodation. I may be getting a call from my doctor's office, and I hate to miss those calls, so I'm going to leave my phone on, and if it's someone other than that, I'll just silence it. But if I do get the call, I may have to step out, so I would ask for your understanding of that accommodation. With that, by the way, for the people in the first row, you don't have to pay attention because I don't call on you. But the other folks, you gotta pay attention. And so in kind of preparing for today, I was asked today to talk about hot topics in special ed law. The one thing we could say about special ed law, it is never the same. It's always evolving. In fact, we have new IDEA regs that were issued in June and July. Fairly minor, most of it change in terminology and so forth, but it's forever changing. Being the paranoid person I am, some people call me obsessive. I even got on the computer this morning to see if there were any new cases from the Ninth Circuit issued. No. But I wanted to bring you the best and latest information. This morning, we're going to be using a PowerPoint. This afternoon, not. And let me just clarify, this afternoon, we are talking about discipline, but we can't talk about discipline without addressing behavior and the proactive expectations that the IDEA places on schools through the IEP team process to proactively work with families in addressing behavior of those children with disabilities who do present some behavioral challenges. So it's going to be behavior and discipline, not just discipline. So just a little clarification. Uncharacteristically, I'm going to start on page 1. And we're talking about a case. Most of these cases are from the Ninth Circuit. And here is a case where the parent and the district, first of all, can I just put in a plug for Idaho and your dispute resolution system? When I'm asked by other states, you know, what states really got it together? I said, no state's perfect. Anybody here perfect? You know, but you come close, and under the leadership of Charlie and Melanie, I am really, really impressed by the array of dispute resolution options, your success rate. I'd like it to be 110% of all cases are resolved successfully, but I really did want to acknowledge while I'm here the hard work that the State Department and the complaint investigators, hearing officers, facilitators, mediators, local directors and other local staff engage in with families to work out differences, because we could be respectful and differ and still maintain relationships. And I sense that's what's going on to a large degree here. So let me just start out on a positive note. You will not see Idaho's name on these cases. In fact, the only case from Idaho that went to court in the last year was a case from a charter school that was alleged to have retaliated against an administrator who was attempting to advocate for kids with disabilities and had some employment actions taken against them. They challenged the charter school, alleging retaliation. The court didn't say that there was merit to that, but they refused to dismiss it. So, but that's the only case that I found that went to court from Idaho, and it did not involve a student. This case, the RA case, involved a situation where a child was autistic. There had been some relationship issues between the family and the school. They determined to settle their differences where the school agreed to pay for a home-based placement. So we're not talking homeschooling, but a home-based placement that the parent would hire a private teacher at school expense to provide services to their child at home. And the parent would agree to the triennial or 3-year reevaluation when it was due. Well, the school did what they were supposed to. The 3-year reevaluation came up, and you know there is a process by which to follow where you get input from the teacher, the parents, and others, and you then what? Provide written notice to the parent of what the proposed reevaluation will consist of and asking for their consent. And that was followed. And the parent said, before I give you consent, I want to be assured that I would be able to observe the child's assessments. The school said, well, we don't normally do that, but they made arrangements to have the reevaluation done in a school that had a room with a kind of a one-way mirror so that you could do a visual assessment, but you could not hear what was going on within the room. The parent says, I want to be able to both visually see what's going on, and I want to hear the assessment being administered. The school said no. The parents then refused to consent. This got to the Ninth Circuit Court of Appeals because they did not have the dispute resolution people from Idaho involved. This got to the Ninth Circuit Court of Appeals where the court said, first of all, and by the way, just one added point to this. The parent said, well, you know, I've had my child privately assessed, and they've allowed me to sit in the room and observe and listen to the assessment, so I don't see what the problem is. The court upheld, so the parents then filed a lawsuit against the district for failing to assess their child. Ultimately, the Ninth Circuit said the school district did not act improperly. the school district was able to articulate the reasons why they felt that having the parent be there physically to both see and hear the assessments could impact. And this is going to get into my statistics class. When I was a double major in education and political science, the last course I took was statistics. I put it off until I couldn't do it. I couldn't put it off any longer. So I don't know if it's a validity or a liability or a little bit of both, but the school was able to articulate why they felt that having the parents' presence there would impact the accuracy of the assessment. The court agreed, and the court said just because another school has allowed that does not a private facility has allowed that does not obligate the public school to. So after all was said and done, you could see on the last full paragraph that the court said that the parents' conditional consent amounted to the improper conditions and was unreasonable, and therefore upheld the school. And I keep thinking, what happens to this child during these years of litigation? Do we have any attorneys in the room? Can you sit closer? But I mean, it takes years to go through the process, to go through the Court of Appeals. Years. And I keep thinking, what happens to this child in the meantime while this adversarialness is going on? Oh, and we don't know. The child gets lost in the adversarial process. So, but I wanted you to be aware of that. I also wanted you to be aware of another hypothetical real case from the Ninth Circuit, and I see this happening a lot in places other than Idaho. Here was a child in a Part C program. Everybody know Part C? You know, sometimes when I do my presentations, especially for parent groups, and I said, well, have you ever heard parent, you walk into the school and the school says, welcome mom and dad to this IEP meeting. We're here to develop your child's IEP that'll provide a FAPE in the LRE, and we may add a BIP. Now you understood what I just said, most of you. In this case, the Part C program, the infant and toddler program, the child was served in the infant and toddler program, and as you know, before the child turns 3, there's supposed to be a transition meeting, not talking post-secondary, a transition meeting between the infant and toddler program and the school-based program. And that took place, and the Part C, the providers met with the school folks and the parents, and the psychologist from the Part C program said, you know, this child has displayed symptoms of autism that I think needs to be pursued. The school did evaluate and found the need to evaluate the student, so they evaluated the student, and they conducted evaluations regarding the child's academic needs, cognitive needs, health assessment, but there were no social, behavioral, adaptive behavioral communication assessments. There was no assessment to determine whether the child was autistic. However, while the child was being evaluated by the school, and the school eventually found the child did qualify for IEP services. But while the child was being evaluated by school personnel, the school psychologist, do we have any school psychs? The school psychologist was asked to stop by the school administration to observe the child. So this was not just I happened to be walking by and see the child. This was a planned, structured observation, by the way, the parent was unaware of. Based on about a 30-minute observation of the child, the school psychologist says, this kid's not autistic, he doesn't look autistic. So no further evaluations were done to determine whether or not the child was autistic. The child's progress under their IEP was not what we had hoped for. The parents obtained 2, not 1, but 2 independent educational evaluations, both of which concluded that the child was autistic. The parent gives the independent evaluations to the school. If I'm a parent and I give you an independent evaluation report, as a school, what must you do? Consider it. Who considers it? The team. And the team considered it, and they said, okay, we'll evaluate the child. They didn't to determine whether he meets the criteria under our state for as a child with autism. I'm in special ed, so I don't have to make anything up. It took them 1 year to do the assessment. In the meantime, the parent sought and paid for private tutorial services in addition to the school-based services that were being provided under the IEP. And after months passed, they finally lost patience and requested a due process hearing. It gets up to the Ninth Circuit. I'm going to kind of jump through to kind of get to bottom line things these days. The Ninth Circuit basically said, in this case, when a school believes that the child may have other disabilities, it's incumbent upon the school to pursue those through an evaluation. Here, during that transition meeting where the school the psychologist that worked with the infant and toddler program raised the question of whether the child was also autistic, the court said that put the school on notice that they needed to pursue that. And I'm going to just quote a little bit here. A school district cannot disregard a non-frivolous suspicion of which it becomes aware simply because of the subjective views of its staff. Nor can it dispel this suspicion through an informal observation. Rather, such notice automatically triggers mandatory statutory procedures. The school district must conduct an assessment for all areas of suspected disability using comprehensive and reliable methods that the IDEA requires. To hold that the school psychologist's informal observation could overcome the school's obligation to formally assess Luke, that was the child's name, for a suspected disability would allow school districts to disregard expressed and informed concerns about a child's disability based on prejudicial stereotypes about what certain disabilities look like, as opposed to objective evidence through thorough and reliable standardized testing. And I'll take issue with the court. It's not testing, it's an evaluation that may include standardized testing. In short, the record reflects that the school was on notice that Luke might have a disorder on the autism spectrum before it provided him with special ed. It was therefore required by the IDA to ensure that the assessment for that disability was conducted. The school said, well, even if the child was autistic, we don't see where the IEP would have been any different. The court said, so, not a quote, the court said, the creation of an IEP is not a unilateral enterprise by the school district, but rather a collaborative process that necessitates parent input. Regardless of whether the school staff might have made identical recommendations, in the absence of informed parental participation in the collaborative process, the failure to obtain the necessary information about Luke's potential disorder prevented an informed discussion with his parents. Thus, the violation deprived his parents of their right to be meaningful participants in the IEP development process. So, FAPE was denied. So what happened? These people are in special ed jail. I'm only kidding, only kidding. But again, it takes years to get to this process. And we, through all these pages, they don't say what happens to Luke in the meantime. And I always want to bring it back to, so what happens to this child through all of this? In most of the cases that I have been involved in, I don't actively practice law, I have seen sometimes where the relationship between the family and school deteriorates to such an extent that the family pulls their child out of public school, either places their child in private school or home services. Questions, comments, especially from my friends, the school psychologists. By the way, the court did not address this, but I'm going to address this afternoon, where the OSEP, the Office of Special Ed Programs, the U.S. Department of Education's office that administers the IDEA, has issued a policy letter that states if there is going to be a structured observation of a child's behavior as part of the assessment data that we collect, that is an evaluation that invokes the due process, the procedural safeguards under the IDEA. What does that mean? That means the parent is to be given notice and give consent to that occur. Now, and I'll get into I'm kind of getting into a little bit, let me just, these days thoughts come and go, so I got to catch them while they're there. The one exception, kid has an IEP goal and behavior. How are we going to measure progress? And it may be through periodic observation. That's a little bit different because that's how we are going to measure a child's progress under their IEP goal of behavior as opposed to what we were talking about here. Any comments or questions or observations? How's the coffee? Bert.
So earlier you had said that the IEP team or the evaluation team has to consider. So if a parent says my child is on the spectrum, my child has ADHD, my child, whatever they bring forth, then does that become a suspected area of disability? Does, as opposed to a team member saying subjectively, well, we don't see any signs of attention deficit, so we're not going to test in that area. If a parent raises it at a meeting, then there may not be anything in writing at that meeting. What would be the next step for the team to not dismiss it and not just make it a subjective response? Would they have to do some kind of formalized assessment because the parent raised the issue?
So I've been asked to try to repeat the question. I'll try to do my best as I understood it. If a parent raises at a meeting a suspicion that a child may have another disability, and they don't do so in writing, what is the obligation, in essence, of the team to address that? Was that, in essence, captures your...
And the writing piece means the parent didn't bring an outside evaluation or something?
The parent just verbally made a request. So first of all, I want to compare your hypothetical with the Timothy O case, where the psychologist from the infant and toddler program raised the issue, not the parent. At the time, it's my understanding, the parent did not have the awareness of the whole process about what to do. And the school said that they were going to assess. In Art's opinion, in answering Mert's comment/question, if a parent raises at a eligibility meeting, at an IEP meeting, or evaluation meeting that their child may have another disability, and I think you used ADHD as an example, I think it's incumbent upon the team to consider it. Even though I don't come with a statement from my child's pediatrician that my child has ADHD, I would want to know from the parent, so what gives you reason to believe that your child may also have ADHD, or whatever their request is, so that we can give, as a team, full consideration and fair consideration to the parent's request. Well, I saw Dr. Phil yesterday, and they had a show on ADHD, and that sounded like my child. I mean, and by the way, that happens a lot. It used to be Oprah. Now it's Dr. Phil. And so I think the team needs to give it consideration and discussion with the parent. If the team is refusing because we see no need, well, let me play two scenarios. the team convinces me that I've been watching too much Dr. Phil. So I kind of withdrew my request, not formally, because I'd never submitted a written request. Then I think as best practice, notations, if you keep notes of meetings are not legally required, although a lot of districts do it as kind of standard practice to show that it was discussed and that the parent agreed at this point there was no need. And the school might even say, well, let's keep an eye on this. Let's not put this to bed forever. If issues arise or continue, let's revisit this. Parent wants the evaluation and the team says no. What procedurally must the team do? Written notice of refusal. Written notice of refusal. Remember, the IDEA says anytime a school is proposing to or refusing to conduct an evaluation, identification, provision of FAPE, or educational placement, the school must provide me written notice. And the written notice requirements is not just the decision, but the reasons why the team made that decision. The evaluation or other data that the team considered in making that decision. Where I could go as a parent to get my procedural safeguards if I hadn't got them before. Where can I go to get additional information about my rights? All that has to be in the written notice. And then obviously that would be subject to my right as a parent to exercise my due process rights. My due process rights. Mediation. It could be in Idaho, where am I? Facilitation. It could be I could get an independent evaluation if I disagree. I could take it to a due process hearing. By the way, the U.S. Department of Education, in a letter to BAUS, B-A-U-S, it's not in your materials, said that my right to an independent evaluation at school expense, the general rule is I have a right to get an independent evaluation if I disagree with the school's evaluation. The feds have said, and one court has agreed, that right extends to not only if I disagree with your evaluation, but if I disagree with your decision not to evaluate. I have a right to get an independent evaluation and request the school pay for it. School has two options. One, tell me where I can get the independent evaluation that meets school criteria, or secondly, the school has to take me to due process to show that its evaluation was appropriate to begin with. Pragmatically, that doesn't make a lot of sense in most cases. Okie dokie. One last case before we, and this was on independent evaluations. And if you're looking, we're on bottom page 2, top of page 3. The parent wanted an independent evaluation because they said the school did not determine whether the child had dyslexia or dysgraphia. And as we know, those are two kind of subtypes under the category specific learning disability. It got up, came from Washington State, got up to the Ninth Circuit Court of Appeals again. They paid more probably in one day of attorney's fees than they would have to pay for the evaluation. Now, did that just go dim? The back screen just went dim. This is okay. Okay. It could be me too. But no. Here the court said the school did not use those terms. However, the school did evaluate them for reading and writing inefficiencies. They didn't refer to the specific labels or categories, but there is no need to. They looked at reading fluency, fine motor skills, aim at detecting writing deficiencies, that there is no legal requirement, and the Ninth Circuit has held this some time ago, for a school to use specific subcategories of LD, such as dysgraphia, dyslexia, dyscalculia, etc. To take this to the Ninth Circuit gives me pause, but I wanted to bring you up to date. I'm just curious, do you get those requests on a school or district level? And how do you respond? There was an affirmation there to that.
To the request for a specific assessment for...
A specific sub-label, so to speak.
Actually, we usually just educate, provide more information about it's a type of reading disorder, disability, and we are assessing, evaluating all of those areas, but we're not making a diagnosis. We're looking at the reading disability.
And I will tell you what's a trend across the country. State laws on dyslexia, where in several states now are required under their state laws to identify students as being dyslexic, train teachers specifically in dyslexia. If a child is deemed dyslexic, the IEP team must consider the following. And I bet you 20 states have such laws. And I'm seeing that kind of spread now. So I'm talking that this interpreted the IDEA and not a specific state law.
Do you think we'll see more of this? Because wasn't there some guidance from OSEP or one of those places that said now schools can use specific?
Sure.
So do you think we'll see an increase in this now?
2 years ago, the U.S. Department of Education issued a memo on this, saying that there would be nothing to prohibit a school from using such terms as dysgraphia, dyslexia, etc. During the evaluation or IEP phases, but there is nothing requiring it. In Art's opinion, I think we're going to probably be seeing less guidance from the U.S. Department of Education. Moving on. Academic or eligibility. Now, this is not a Ninth Circuit case, but it's getting a lot of attention in the world of special ed law. Page 3, paragraph 2A. And we're still going to continue without, I don't know what happened technologically. The technological gods got in.
Jessica's working on
Okay.
it.
Here was a child who had been deemed to have a specific reading disability based on deficits in reading fluency, starting in the 2nd grade. She was placed on an IEP. She was placed on an IEP from 2nd grade. She performed very well in school, pretty much had an A average. On state assessments, she was doing very well. You know, now when we're talking about assessments, not individual, but statewide assessments that used to be required by the No Child Left Behind Act, and now it's the Every Student Succeeds Act. In 7th grade, the school determined that she's doing so well, we don't think she really needs special ed anymore, so they placed her on a consult IEP. And I'm going to ask you to discuss, because I just see I got an email from my doctor. I can't help myself. To recommence, they said, oh, we'll be in touch. Thanks. So, okay, Art, reel in. So in 7th grade, they put this child on a consult IEP. What does that mean? And sometimes I've heard it called a monitoring IEP, where we don't want to take the child off, so we're going to huddle around her and make sure that she continues to do well and not regress, but she was getting no services. So my question from a legal perspective, why was she on an IEP if she wasn't getting specially designed instruction? And I don't want to question the motivation. I've seen this fairly common, where a school will continue the child and kind of incrementally step back and then actually even cease services for a period to see if the child is maintaining their progress. The court, by the way, didn't address that. The student continued to do well. Did I do something?
Oh, no, you're okay, you're fine.
I'm not fine, that's a whole nother issue. I don't want to get into that. In March of the 7th grade year, they held an IEP meeting and exited her from special ed because she was no longer in need of special education. The parent, and by the way, they were providing reading probes along the way. The child's academic grades were way up there. Thank you. The child's academic grades were way up there. Again, her state test scores, kind of the cream of the crop. Her reading fluency probe showed that she had acquired solid fluency skills. The parents got not one, but 2 independent evaluations. And the independent evaluators administered many of the same instruments and reading probes that the school did and got the same results. But they also administered others that showed the child still had deficits in reading fluency. The team considered the independent evaluations and maintained that the child no longer qualified for special education because there was no need for specially designed instruction. The parents challenged that. It gets up to the Court of Appeals. By the way, the hearing officer in Massachusetts found the kid was not eligible. The federal district court said the child is not eligible. The Court of Appeals said, maybe. The Court of Appeals did not find that the child was eligible, did not find that the child was ineligible, but found that the team did not make a proper determination. And if, first of all, just because a child is doing well academically, just because the child's grades are strong, test scores are strong, etc., in and of itself is not determinative of whether a child qualifies for special ed or not. By the way, I'm going to say the converse is true. We don't want any kids to fail, but just because a child is not doing well in school doesn't mean they're disabled and in need of special ed either. That's not an automatic the other way. In this case, the court said overall academic success is a legitimate consideration, but in order to use that as a basis for their determination, the team must articulate a nexus. What does that mean? A connection between the skill, in this case, the deficit in reading fluency, and these academic measures. And the Court of Appeals felt neither the team, the hearing officer, or lower court clearly articulated that nexus between the strong academic performance and her reading fluency, what the court called deficiencies. The court said, among other things, the emphasis is on a holistic approach in identifying a specific learning disability. And they also looked at the comments in the 2006 IDEA regulations. That was the last time that were comprehensively reviewed. And several people made comments to the feds that under LD, the issue of reading fluency as a skill should be removed. The feds refused to remove it. And in doing so, stated, we defend our action to include reading fluency as a category because including reading fluency in the list of areas to be considered when determining whether a child has a specific learning disability makes it more likely that a child who is gifted and has a specific learning disability would be identified. When the risk is high that a child's overall academic performance could mask her learning disability because of innate or ancillary factors specific to that child, and the regulations included that disability category to mitigate such masking. Generalized academic measures, even when to be proven to be a fair indicator of the child's learning disability, must have a high probative value to outweigh the specific disability measures in identifying LD. Here, they just said that the team and the hearing officer and the court did not make a proper determination and sent it back all over again. This child will be in postdoctoral training when all is said and done. But again, I think this stands for a couple things. And OSEP, a couple years ago, issued a memo just reminding us that a child with strong academic performance measures may still have a disability and be in need of special education. This court said, in order that strong academic measures are relevant considerations if they are what? Related to the area of qualification, in this case, reading fluency. And they said that the team did not properly address that issue of making that connection. I was just in a state recently, we'll call it the state of confusion, where I got challenged on this. And they said, if a child's getting all A's and B's, they can't be on an IEP. I don't believe that is in keeping with the IDEA. That I think it's a determination, but we don't determine what. First of all, how many of you have been teachers? I was a high school teacher before I went to law school, then I taught at the university. I mean, we all know that too. Grades are somewhat subjective. It's not just looking at the skill, but the effort, participation, etc. So looking at grades is an important factor, but not the determining factor. And what has the IDEA always taught us? Never rely on one piece of data to make a decision. Even though that data could be relevant, we don't rely just on a test score or just a grade to make a decision. Yes?
Well, I was just going to comment. I think that is where we really have to delve into the adverse effect of second prong. Was there an adverse effect in any way? And that would help us determine.
The comment, and I'll repeat this, was, well, that's one of the reasons we have to delve into whether there was an adverse effect to determine. You're absolutely right, because the three major questions for eligibility: does the kid have a disability which adversely affects educational performance, putting the child in need of special ed, specially designed instruction? So we really looked at adverse effect and specialized instruction are kind of married in some respects. And let's move to the next case that illustrates that a bit more. Case out of the Sixth Circuit. Here was a child who was found eligible in California as a student with autism, high functioning, was on an IEP in California. His parents moved to Kentucky. The education records actually made it from California to Kentucky. Let us stop, let us celebrate. Not only inter-district, interstate. I was a surrogate parent for 13 years for kids in our juvenile detention facility back home. I had to call Perry Mason sometimes to try to find these education records. I mean, where did they go? But so the records made it. Kentucky got the records, adopted the IEP from California as theirs, and continued to provide services. The child did very well, academically, socially, and academically. The next year, the 3-year reevaluation came up. The school reevaluated the student and felt, well, the student still is on the autism spectrum. You don't grow out of it. But that there was no adverse effect on education performance, putting the child in need of special education. The parent said, well, that might be true in school. And by the way, from what I read in the case, the parent did not dispute that this child was making this progress in school. Not just, and everybody agreed, educational performance is more than academic and includes social, behavioral, psychological factors. So everybody was on board with the broader definition of educational performance. But the parents said, our child's behavior at home has not improved. He engages in self-injurious behavior. We can't take him out to dinner because he is so disruptive. He's not able to focus. He's not able to maintain. So whatever you're doing in school is not translating in his ability to generalize that progress to other settings. So school, you have to consider that in terms of adverse effect in addition to his in-school performance. The court disagreed. The Court of Appeals for the Sixth Circuit, Idaho is in the Ninth, and Idaho hasn't addressed this, or the Ninth Circuit has not addressed this head on, basically held that the parent's position would have no limiting principle. They would hold schools responsible for a child's behavior no matter how far, I think attenuated is what they use, or removed from the school day. We find that the IDEA's purpose was to provide a free, appropriate public education. The court says we see educational performance which suggests a school-based performance. By the way, school-based is not just classroom-based, but school-based. In this case, the case was appealed to the Supremes, but the Supreme Court they get to do whatever they want. They said no thanks, so they didn't take this case. So this was a case where education or adverse effect came up, and the court held adverse effect focuses on the child's performance in a school environment and not at home. By the way, when I read this case, I often think of, and I'd like to just get your response to whether you've seen it in many cases, a reading from the federal regulations. 300.34B8. The related service of parent counseling and training. Parent counseling and training means assisting parents in understanding the special needs of their child, providing parents with information about the child's development, and helping parents to acquire the necessary skills that will allow them to support the implementation of their child's IEP. So even before this child was exited, if we are experiencing the success in school and the parents are reporting they're not seeing the same success at home, what steps have we taken? And we would have to get Dr. Freud involved, because I know as a parent myself that my child and my kids will always be my kids, but they are young adults now, that their parents could tell them something that they might not take as well as other individuals, like their school people. We had a school administrator for my oldest son. High school was not a fun time. She got him through high school and got him into college. Well, he got into college because his mother was dean of students. But but I see this administrator who's retired, and I said, we still have your picture with candles burning in front of it in our house, you know. But she saved his butt. But what I'm suggesting here, if we're seeing the success in school, have we given the parent some pointers, or having to come in so they could observe modeling, working with their students, so they may try to engage in those same steps at home and may see some progress? How many of you have seen parent counseling and training in an IEP as a related service? I see one hand. I know it's kind of a quick half hand. By the way, that's been in the law since 1978. When we talk about behavior this afternoon, if a child has a behavioral goal with behavior interventions, I'm going to suggest it's going to be almost impossible not to consider parent training and counseling on those behavior interventions, because there's a lot of folks here who are experts in behavior. I'm not. people I rely on talk about one important factor is what? Consistency. So that the family is being consistent with what, in interacting with the child with the school. We'll talk more about that this afternoon. Yes, ma'am?
I was just going to mention that our Part C services often help with the education. That's what we focus on.
The comment was that the Part C infant and toddler program often has family services, and even the IFSP, the Individualized Family Service Plan, focuses on not just the child, but the child as a member of a family. But this is Part B that I'm talking about and that I just read to you. So think about that as you go on in terms of whether parent counseling, if there's, especially regarding socialization and behavior, where they're reporting that they're not seeing the success that you have experienced with this child in school. And I'm not there to say that means that the clouds will part and everything will be fine at home, but a good faith attempt. Okay, one last case on eligibility from the Ninth Circuit. I have to let my blood pressure go down. Here was a child who's in second grade, not on an IEP. His behavior started escalating. He was, quote, bullied other kids in the classroom. His teacher reprimanded him for not following rules and for bullying other children. He had a meltdown and screamed, "I want to die. Life is too hard." This is a second grader. I'm hearing from some people, they are hearing from kindergarten kids who want to kill themselves. I can't even go there. I have a grandson now who's 16 months. I just can't even. A second grader. The school did what they should have, called mom immediately. Well, they should have called dad too. I want to plug for dads. But they also called mental health. And mental health came and did an emergency mental health evaluation, a suicide prevention evaluation. The child was also referred to the school's counseling center. And the counseling center in the school district was kind of the evaluation center. By the way, the child was referred there not to determine whether he was IEP eligible, but as a result of his little outburst. The school diagnosed this child as having ADHD, ODD, oppositional defiant disorder, and a bipolar disorder. The school did. Through the counseling center. They called it the counseling center. It was really an evaluation center run by the school district. They then called a student study team. What did you call that? Like a problem-solving team, to use Idaho's terminology. So a gen ed team to talk about what can we do to support this student. And at the student study team, they said, well, we need to develop a behavior support plan for this student. And we are going to have our behavioral specialist work with the teacher to develop a behavior support plan. We also think that this child should be transferred to another program within our district for children who have extreme behavioral problems. Now, this is the only place where this came in kind of through the side door. The other program where they were proposing to place this child was then defined by the court as a program housed in a trailer behind the school with 6 other African American males. That's the only place where race of the student was kind of alluded to. When mom found out, she said, I think not. She hired an attorney, And the school and the family agreed to go to mediation. And it reached settlement. The mediator was successful. As part of the settlement, the child was placed in a different gen ed class, was not placed in the trailer program. The child also had a one-on-one paraprofessional assigned to him in that gen ed class. And the school agreed to evaluate this student for special ed. Remember, at this point, he had not been found eligible for special education. The school psychologist conducted the evaluation, did a functional analysis, interviewed the teachers and the family, and the psychologist determined that the child was not eligible. While this was going on, the child tried to kill himself at home, put a finger in the light socket, and then swallowed a piece of metal. And said everyone hated him. Parents had taken him to a psychiatric hospital at the time. While he was in the psychiatric hospital, they held the IEP meeting, and the eligibility meeting, and found him not eligible for special education. And let me just say a couple things. Have you ever been in a meeting, whether it be, in this case, for a child who may be emotionally disabled or LD, and the team members turn to the psychologist, did she qualify? Have you ever seen that? Remember, the school psychologist here concluded that the child was not eligible. First of all, the school psychologist plays an important role as a team member. So the team just kind of bobbed their heads, and the child did not qualify. The child is released from the hospital. End of the school year, the child is back in the hospital over the summer because he had again attempted to commit suicide at home. The parent requested a due process hearing. Mediation number 2 took place. They moved the child yet to another school pursuant to the mediation agreement. Mom agreed to release the psychiatric records, the discharge records from the hospital to the school to consider as part of the school's commitment to do another reevaluation, and on the condition that the nurse would also conduct a health assessment. Guess what? The school never followed through on the mediation. Mediators, you know what the trust level falls apart. So they're back in litigation. Ultimately, they met again, found the kid ineligible yet once again. Kid tried to hang himself at home. At this point, he was in the 4th grade. So, multiple attempted suicides. It gets into court. It's important to note, when we got to court, the school acknowledged that the child was emotionally disabled under the IDEA. So the first prong, they said the kid was emotionally, actually the legal terminology under IDEA is emotionally disturbed. And as we know, that's more than having a bad hair day occasionally. However, they said the child does not need special ed services. There is no need for specially designed, no need for specially designed instruction. The court said, specially designed instruction. General ed instruction does not typically include extensive clinical interventions by a school district behavioral specialist. While it's not unusual for a behavioral specialist to offer support to a gen ed teacher, here the behavioral specialist did much more. he designed a specific behavior support plan in an attempt to meet the child's needs. The plan included adapting the method and delivery of instruction and strategies to promote a structured environment and reinforce positive behavior. What's the definition of specially designed instruction? That's it. The behavior specialist also designed a 9-hour training session for the paraeducator assigned to the child and supervised the paraeducators carrying out of the behavior plan. The school took the position that his psychiatric hospitalizations and suicide attempts were not relevant to his eligibility for specialized instruction because they occurred outside the school environment, except for that first one way back in 2nd grade. The court said, Ninth Circuit, the issue is whether his disabilities interfered with his education and necessitated special services. It's hard to imagine how an emotional disturbance so severe that it resulted in repeated suicide attempts would not interfere with school performance. That he attempted suicide outside the school environment is immaterial. His emotional disturbance adversely affected his attendance, and his teachers all reported hurt his academic performance. To distinguish between where a student attempted suicide between home and school misses the point. The point being whether having a suicidal ideation and attempting suicide interfered with his education, putting him in need of special ed. The court said yes. And going back to the behavior plan, what's the definition of specially designed instruction? Modifying, adapting the content, delivery, or methodology of instruction. Those words were in the behavior support plan. My question is, why didn't the school just put him on an IEP? At break, if anyone wants to join me outside for a group primal scream. Hearsay said that this school district was under a directive for overrepresentation by the state. And remember, the only place where the kid's race was kind of implied was where the court said he would be placed in this program with 6 other African male students. So you get dung by the state. You have to do what's right for that individual child. And to litigate this for years. Poor child. On the other hand, I want to acknowledge the school didn't say, not our problem. I mean, they did provide supports. And this was all on the need for special education. The last is a fairly recent guidance document that came out in May from the feds to the states saying, just review your state criteria under visual impairment and blindness. There are no qualifiers. There are no qualifiers in the IDEA, and therefore any impact of visual impairment, it says any impairment of vision, regardless of severity, would qualify if there's an adverse effect on education. So that's, as I understand, resulting in some discussions in states to determine whether refinements need to be considered. I see some verbal communication. Would anyone like to share the?
Oh, I just had a parent call me, yeah, just a couple days ago, and it was unilateral, you know.
A hypothetical parent.
A hypothetical parent, yeah. And I read her from the SPED manual, you know, the definition of the eligibility criteria, and,
And the feds put this out because they said states and districts need to take a second look at their processes for determining eligibility under this particular category. I am not here. I have no opinion as to Idaho's eligibility criteria, but it kind of raises a question, do we need to reflect and determine whether refinements are needed or not? Questions on evaluation and eligibility before we move on. Let me just check here. Who's having fun? We have one person having fun. Let's talk about FAPE. In 1982, the Supreme Court defined FAPE, meaning did the district adequately comply with procedures, and as a result, was the IEP reasonably calculated to allow or enable the child to receive educational benefit? On that second prong, more recently, the Supreme Court, in a case called Andrew F., revisited and refined what educational benefit is. But I want to stay with the first prong for a while. In Art's opinion, the Andrew F. recent Supreme Court case did not overturn Rowley, but refined Rowley. And so adequate compliance with procedures still is a criteria. Tomorrow I'm meeting with the complaint investigators who investigate state administrative complaints. They have to hold a district not to adequate compliance, but full compliance with all procedures. We'll talk to them more about that tomorrow. So let's talk about some new cases under alleged procedural problems. One, parent participation is very important. This case is from Arizona. I understand it is on appeal to the Ninth Circuit. That's one of the reasons I raised it. So the school contacts me, the parent, and we find a mutually acceptable time and place to hold my child's IEP annual review. I am bringing my advocate and my educational consultant with me. The school tells me that the IEP meeting will last for 2 hours next Monday afternoon. We show up on time, and after 2 hours, business is not all finished yet. And that the IEP has not yet been finalized, and the annual review date is coming up here. The education consultant that I brought with me expected that the meeting would last 2 hours and made another professional commitment that she had. So she had to leave the IEP meeting. The parent and advocate left with her. The school said, please stay. We are going to continue so we can finalize this IEP here. It's taken us longer than we first thought. But we need to have a final IEP. If you do leave, we pledge that we will hold future meetings to determine whether additional refinements will be necessary after we finish our business here today. They left. The school completed the IEP, sent the IEP to the parent with prior written notice. The school then also held 2 additional IEP meetings and made some changes to the IEP as they told the parent they would, made changes to the IEP at the parent's request subsequent to the annual review. The parent challenges the IEP, primarily that they were not given the opportunity to be full participants in the decision-making process. And they cited an old Ninth Circuit case, it's about 3-4 years old, called Doug C. versus Hawaii. The court here said, no denial of FAPE. The parents were actively involved, along with their advocate and education consultant, during the 2-hour period. The school finalize the IEP with the commitment that they would hold additional meetings to determine whether additional refinements needed to be made at the parent's request, and indeed 2 additional meetings were held and refinements were made. The fact that the parent wasn't there for the entire meeting and left of their own choice, but they were told, the expectation was that it would be 2 hours. The court held that there was no violation of the law. And the Doug C. case comes back to haunt a lot of districts. Doug C. is not in your outline, but let me just do a brief review. And by the way, I was under contract with Hawaii for 20 years that ended June 30th. So I'm no longer under contract, but I was under contract with their administrative law judges also. And in the Doug C. case, there was a history between this family of a child with autism and the Department of Education. Hawaii is unique in many beautiful ways, but the whole state's one school district. Prior to this, there had been, I believe, 12 court cases involving this family and the department. So shall we say there was a rich history. And many honorary law degrees were earned along the way. But this kid was in private school, placed there pursuant to a court order. The school year was about to end. The school started approximately 6 months before the IEP expired, but by expired, the annual review date, trying to find a mutually convenient time and place. They finally found one in October. They started in September. The IEP annual review date was the first week of November. The week before the meeting, the parent is called. It was Dad, was the lead parent here. Said, just to remind you, we're meeting next Tuesday at 10 a.m. in the school conference room. Well, I'm glad you called. I'm really unable to be there. So they engaged in conversations and found a time the following week, which was like 3 days before the annual review date, to meet. The morning of the scheduled meeting at 7:27 a.m., the school administrator gets an email from the parents saying that they're ill today. And that happens to all of us. Unanticipated issues come up with our family, ourselves, etc. The school contacted the parents and said, I'm sorry you're not feeling well. We will make arrangements for you to participate via teleconference, or can you meet tomorrow? Well, I'm not sure I'm going to be feeling well enough to meet tomorrow. And no, I want to be there in person. The school said, we have to meet before your child's IP expires. And they used the term expires. So, but we will then hold another meeting with you when you're feeling better to review and determine whether additional changes need to be made. They held a meeting. And the meeting changed the child's placement from a private special ed school to the high school, public high school. Special program in the public high school. An additional IEP meeting was scheduled about 3 weeks later when the parent said they could be there. The day before the rescheduled meeting, the parents files due process. Gets up to the Ninth Circuit. The Ninth Circuit invalidates the IEP. The Ninth Circuit said that when you have 2 competing interests, 1, parent participation, 2, maintaining compliance with timelines, parental participation trumps. Shall we say the case was settled for 7 figures. And this case is being cited around the country. This court in Arizona said this case is distinct because here the parents did attend IEP meetings and actively participated. They did follow through on additional meetings, By the way, Hawaii, the Ninth Circuit said holding additional meetings after the decision is made is too late. Here, the court made the distinction the parents participated not till the completion of that IEP, but participated in its formulation. So, I always tell districts too, don't schedule the IEP annual review on the annual review date. I like odd numbers, so I say 3 weeks ahead of time, at least. Because one of your staff people may not be able to attend. You may need to hold part 2 of that meeting before we finalize that IEP. Give yourself some wiggle room. Next, and look, if you see my comment on the bottom, doing just what is legal is not always right to do. We have 2 cases now, one from New York and one from Rhode Island, where the parent wanted to visit the proposed IEP placement. The JB case, the child was going to be placed in a self-contained program that was housed in another school other than their neighborhood school. The parent said, before I agree or disagree, I'd like to kind of visit the program. So the school said, fine, here's the name of the person and the phone number of the person to call at that school, and you can call them and schedule a time to go visit the program. Well, there apparently was phone exchanges taking place. The parent had, after several days, the parent said, we have a vacation scheduled, we're leaving. We come back the day before the school year starts. So they never had an opportunity to view the program. In the other case that's cited in your outline that's not here, it's called Maureen versus Cumberland. The parents wanted to see the program, and the school said you could only see the program after the school day because of confidentiality. It's a self-contained program, meaning only kids on IEPs are in that program, so you can't see the program while other kids are there, but only after the school day. The parents said, we kind of want to see it in action. The school said, we will make arrangements for you to come see the program after the school day, talk to the teacher, have questions for the teacher, but you can't come during the day. In both cases, the court upheld the school's position. Parents do not have a right under the IDEA to visit assigned school placement options either before the recommendation is finalized or prior to the school year. As a parent, I kind of understand that I kind of would like to see, if I'm not familiar with, what this theoretically looks like for real before I make a decision. I'm not aware of any court that says parents have a legal right to do so. I tell schools, do you really want to go to legal war over this? You may prevail and lose big. I think it's reasonable for parents. Now, by the way, in the Rhode Island case, so all these kids are special ed kids. I think, I have opinions on everything, right, Melanie? Right, wrong, but I'm never indifferent. I think it would even be permissible for that parent to visit the classroom with those kids in attendance. And what I'm about to say, it's called tact. So the school person, who is kind of the person accompanying the parent, needs to say, well, you know, here's the class that we are proposing for your child. Melanie Reese is the teacher. As you can see the class, instead of saying, you see that student there? I think you live in the same neighborhood as the Simpsons. This kid's a handful. In other words, you stop there. The fact that all these kids are on IEPs, I applaud the sensitivity of the school regarding confidentiality, but the fact that I'm walking by a room and it happens to be a special ed room, or if I walk in that room, is that a breach of confidentiality? As long as I don't identify those children? And even though I might recognize one of those kids who lives in my neighborhood. I used to volunteer a lot when my kids were in school to be chaperones, especially when they were going to some neat places. And at times I needed some pretty personal information about some kids with some health issues. What did the school do? In those cases, got permission of the parent to share that information with me. But in just viewing a classroom with kids sitting there, I'm not sure I'm going to be crying crocodile tears over a breach of confidentiality, as long as the school doesn't take it to the next step and start pointing out kids by name, etc. Or if the parent says, oh, I know that kid. Well, we're here not to talk about specific children, Mom and Dad. We're here to kind of give you a sense of the classroom. Doing what is just what is legal is not always the right thing to do. Questions, comments?
I have a question going back to the Doug C. case and then the case in Arizona. If it becomes clear that you're going to have an issue with the timeline and that the IEP date is coming close and for whatever reason parental participation hasn't happened yet and isn't going to in time, what's the best way procedurally then to handle that? What would you document? What sort of notice? And how would you ensure that if, the IEP date is April 1st, how do you handle it until you meet with the parent on April 10th?
The question is, going back to the previous case from Arizona and my discussion of the Doug C. case, what would be the best way when you are facing the annual review date and the parent is unable to participate until after that date? How do you, what documents or what here's what I think is the option that I thought of that I think both would keep you in compliance and afford the parent another opportunity to participate. And I want to say this carefully. In the Doug C. case, the same attorney was involved in 2 other cases with 2 other parents who engaged in the same behavior of canceling meetings. At the due process hearing, the parent was asked, well, why did you keep canceling meetings? Well, my attorney told me to wait until the morning of the meeting and cancel. The attorney jumped up and said, I want that stricken from the record. It was refused. So, I will say, in that case, there's a question of whether there was a little manipulation of the system. By the way, on the other hand, just because at the end of the day of the meeting, I cancel, there should be nothing like a malicious intent to get you should not be automatically concluded. Here's what I think could happen. You could amend the IEP between the annual review dates with the authorized representative of the school district or charter school and the parent. And then the amendment between the annual review dates. So we amend the IEP. So parent, I know you can't meet before August 1st or whatever the date is. Would you agree to amend your child, to create a new IEP that will go from August 1st to September 1st? We will continue the same services that we are proposing, but the dates will change. And if you agree to that, while we're on the phone or talking here, let's agree. Let's look at our calendars and find 1, 2, or maybe 3 dates that are good for you to meet and good for us to meet and put them on our calendar. So we both have extended no, we haven't extended the IEP. We've created a new IEP.
Identical to
An interim IEP, so to speak. So you don't have an IEP that's, quote, expired. And you have given the parent another opportunity to participate. I think that's one way of doing it. I am not a spokesperson for the Idaho Department of Education, so I don't know if the department would concur. But to me, it would show a good faith on the part of the district, especially in light of Doug C., when you're faced with those competing challenges, and you can't, don't call it it is an extension, but I would say we are creating another IEP on an interim basis for a short period of time, and setting some dates to allow the parent to participate to determine what refinements, if any, should be made in the IEP after the interim IEP is over with. You follow? That's the best thought I could come up with the solution of how, because you let by the way, the Doug C. attorney in another case where the school rescheduled the IEP meeting at the parent's request after the annual review date. The date after the annual review, he filed a due process hearing alleging that there was no offer of FAPE because the IEP had expired. By the way, the court found for the Department of Education, saying that they gave multiple opportunities to do so and that there was a manipulation of the system. And that the only reason the IEP meeting was rescheduled was at the request of the parent so they could participate. By the way, we have people in the legal profession, the teaching profession, and others. We always have some individuals we would like to encourage to pursue other professional options. And I don't want to paint the picture just because I'm a strong advocate or a strong special ed administrator or teacher that I'm acting in some sort of, have a malicious intent here. But I was trying to think of a way to kind of balance both of my responsibilities.
So, hypothetically, we have this problem. What we've kind of done is...
Did not.
When we have the conversation with the parent, we document that in our phone conversation that we'll continue to provide the services that are on the IEP until we have our meeting date. Then we follow that up with an email, also documenting our conversation, and then a written notice that says that. So rather than doing IEP, we have it all documented.
So the comment that was made was the practice when such a hypothetical might arise would be, would the parent agree to continue services even though the annual review date has come and gone, and you would document that, send an email to the parent and also a written notice to the parent. And even though the state may ding you for not having an IEP in effect, that would be, so you get dung.
And hypothetically, we have unwritten notice. We will continue to provide all services in the IEP. We'll continue to provide safe and offer all services on the IEP.
And that we are rescheduling the IEP
Right, for this
solely at the parent's request so that they could participate.
And hypothetically, the IEP team meeting facilitator contacted the parent for the same documentation.
And the parent hypothetically concurred?
The parent hypothetically did not respond to the facilitator.
So I think it's time for a hypothetical break. Let's take 10.
Okay, this before we close that up. So, this is not a hypothetical question.
Yes, it is.
What is our State Department's response to the suggestion that Art had of how to word that?
It all depends on whether there's a complaint. Okay. If it came to a complaint, our complaint investigators have the responsibility to find compliance or non-compliance. However, there is always the eye of looking at something with some empathy. And so, particularly in the case that's hypothetically being discussed here, we were very aware of what was going on, and we're very supportive of the districts and this facilitator's efforts to cover thy fannies. So.
And again, based on a binding Ninth Circuit case that said when you have these competing interests, the core principle of parent participation is so important that oftentimes that it will trump simple timeline compliance.
I guess I would comment on the term interim, since our IEP form includes a begin date and an end date. It's just another IEP.
It's a short-term IEP.
You can do it for a week, you can do it for a month.
Absolutely.
Whatever, it's still the IEP.
It's still an
And
IEP.
So there would be no compliance issue at that point.
That's why I was suggesting
Yeah.
that. A short-term IEP,
Yeah.
kind of a bridge IEP to the next one. Short-term, interim, I think we're all talking the same thing.
Absolutely.
Let's take a 10-minute break, and I'm going to guarantee you we are not going to go through every single case in the outline. So I want